Hello, my name is Glen Olson, and I'm a partner with Long & Levitt in San Francisco. I do professional liability defense work, defending mostly lawyers and law firms in legal malpractice cases, and I also advise lawyers on their ethical obligations when situations such as conflicts of interest arise. My topic today is communications with or about a dissatisfied client. And these are situations that arise often when a client asserts a malpractice claim or expresses dissatisfaction, for instance, with the amount of billing that a lawyer has done on a particular file. It's also possible that the lawyer has made an error, and then there's a juncture at which you have to make a decision about how to disclose the error to the client and what the contents of that disclosure is going to be. And in my practice, I typically see errors in the form of missed deadlines, conflict of interest issues where people are representing adverse interests as between different clients, and also simple billing and reporting issues where people haven't been reporting to the client in the way that they should, and then the client becomes dissatisfied. So what do you do when these situations arise, when you have a situation where you have an unhappy client and maybe the client has expressed displeasure either in writing or orally to the lawyer with the way that the representation is going? The first step is you have to look hard at the rules of professional responsibility, and in California those are grounded in our Business and Professions Code and also the California rules of professional conduct. And Rule 3-500 talks about disclosing to the client material events and material facts that can affect the representation. And there's also model rule of professional conduct in the American Bar Association rules 1.4, which talks about disclosing to the client events that can affect the representation and as to which the client needs to make a decision one way or the other in terms of how the representation is to go forward. Now, the ABA rules are not governing in California. We look to our own model rules of professional conduct rather than to the rules of the ABA. But I often find that those ABA rules provide a little bit of guidance and also a little bit of depth when it comes to what types of things need to be disclosed to the client. So let's say you have an error that you're considering disclosing to the client. In most instances, you're going to find that if there's a material impact on the representation, that's something that you have to bring to the client's attention so that the client can make a decision to continue with the representation, retain other counsel, or take other measures that the client needs to take to protect their interest. Once you've made that disclosure, what happens in terms of communications? Who are the parties that you may be communicating with in the context of a malpractice claim or a potential malpractice claim? And there's a number of different parties that fall into these communication categories. One is your insurer. You may be contacting your insurer to report a potential claim. Another is potentially the state bar. You may have to self-report, and you should be aware of your self-reporting responsibilities if there's been a material event that's impacted the representation. Another is your partners. If you're in a partnership, you may have to disclose to your partners the error, and you may want to do that in an early stage. And of course, I've talked about making the disclosure to the client. So what are the rules of privilege when we start talking about these various communications that you can have with other parties following a malpractice claim or a potential malpractice claim? With respect to your insurer, the law recognizes that communications in anticipation of litigation, and this goes back to the D.I. Chadbourne United States Supreme Court opinion, are generally considered privileged. And that's going to be important because at the end of my talk, I'm going to give you some tips about what I think you should do when you get into a situation that could be a potential malpractice claim. So those are generally considered a privileged communication when you are reporting something to your to your insurer that could either give rise to a claim or has become a claim already. What about reports to your partners? This turns out to be more controversial because there's somewhat of a split in the federal and the state courts about how to handle those situations. There are two federal trial court opinions that are reported in Westlaw. One is called In Re Sonic Blue, and then the other is called Thielen, Reed, and Priest versus Marland. And in those cases, the federal courts reasoned that when you have a malpractice claim and then you begin to communicate with your partners, you're essentially in a conflict of interest position, and the fiduciary duty that you owe your client trumps the application of the privilege. Fortunately for California lawyers, the issue has also been addressed in a case called Palmer versus Superior Court, and I think everyone should read this because it's a very important case about privilege and lawyer malpractice claims. Palmer is reported at 231 Cal App 4th, 1214. In the Palmer case, there was essentially a right of privacy action that the law firm pursued, and they drew a malicious prosecution action in response to the action that they filed on the client's behalf. The client became immediately unhappy with the situation, particularly the amount of billing that was taking place on the file, and threatened a malpractice claim and ultimately filed a malpractice claim against the law firm. The law firm had in place a general counsel and ethics counsel structure whereby if lawyers had problems, they could go to the general counsel and report to the general counsel on the situation. And that's what the lawyer did in the Palmer case. And they generated quite a bit of email activity back and forth with general counsel and also a separate ethics counsel creating a set of recommendations for how to handle the situation. At the end of the day, when the case got up to the Court of Appeal, essentially reversing a trial court order, the Court of Appeal determined that these were in fact privileged communications, and the court disagreed with those federal court decisions that I've discussed, reasoning that in California our privileges are statutory in nature. So only the legislature can create exceptions to privilege, such as a current client conflict exception or fiduciary duty exception. So Palmer's a very good case for us in terms of vindicating the idea that if you have a general counsel or if you have an ethics counsel and you communicate with that person, then those are privileged communications. Now that may be cold comfort if you're in a small firm. What happens if you're a solo practitioner or you're a small firm with maybe 2 or 3 partners? Now you have a malpractice claim. It's certainly something that you want to disclose to your partners. How do you handle the situation? And I wanted to just provide some tips because I'm aware that most people do practice in the smaller law firm world. Tip number 1 is bring your insurer into that discussion early, because that's going to be a privileged communication. And if you're generating a number of emails, for instance, those emails can be shielded by privilege if you're communicating with your partner and with the insurer. And the insurer may actually appoint a pre-claim defense counsel, get them on board early. That gives you a much stronger case for privilege. Second, I would say avail yourself of ethics hotlines. I mean, those can be anonymous inquiries either to the state bar, to your insurer. By all means, use those resources if you have a problem you don't know how to address or solve. I would say, by all means, go ahead and do that. The other thing I think that people should seriously consider is do not build a huge email bank reporting on a claim, and think about need to know. Does everyone that's on that email chain discussing a particular malpractice situation really need to know that information? Are they really participants? You don't want to get in a situation where you have people potentially waiving privilege, and there are folks that didn't need to be in the chain in the first place. And then I think most important of all is always think when you're communicating about a malpractice claim that this could be a discoverable communication. This could be something that people would find through a waiver that somebody could inadvertently produce at some point. So do not disparage the client. Certainly never disparage or show disrespect for judges or juries. Those types of comments are potentially devastating when they're in writing, and they really need to be avoided because you never know about privilege. So anyway, those are some tips that I wanted to provide about how to handle these situations. I would say read the Palmer case, and I hope this is helpful to your practice.